Dr. Charles Sibley for his announcement, the Honorable Judge Webb presiding.
Thank you. Be seated, please. I've got the defendant's motion to dismiss. Is that what's before the court? That's the only motion? I have to look around here.
Yes, sir.
Yeah, we're here back here, so who all we got for our record? We'll start with the petitioners.
Yeah, Howard Brown.
Howard Brown.
Brandon Sibley.
Brandon Sibley. All right. And for the defense.
Brian Rogers, counsel for the tribal defendants, and Diane Maxwell, the attorney general for the tribe, as the party representative.
All right. Very well. You ready
Ready to proceed, Your
All
Honor?
right. You're ready. And whatever's easier, we've got microphone. Y'all can stand here, or if you've got a lot of paperwork, whatever makes you work.
I might try to start here, and I might end up
Or
there.
you can move around.
You can tell from my voice, I'm a little under the weather today.
Okay. All right.
Okay. Your Honor, this is the third lawsuit that the petitioners have filed against the tribe and tribal officials regarding the masking rule that was initiated during COVID, authorized by the council's ordinance and then executed through an executive order issued by the chief that required masking to enter any of the tribal facilities. Plaintiffs or petitioners have filed a number of claims, constitutional, statutory, and one tort claim, seeking monetary relief, about $700,000 or $800,000, and injunctive and declaratory relief because they were denied entry into the Golden Moon when they refused to wear a mask. And they filed an initial suit in the U.S. District Court, and the tribe secured a dismissal of that suit because they had failed to exhaust tribal remedies. They then filed a Choctaw Tort Claims Act notice, which was rejected as untimely. They went back to the U.S. District Court, said they had exhausted tribal remedies. We showed the court they had not, because they had never come to this court, and they had many other claims besides the one tort claim. The district judge in the second case stayed his case pending exhaustion of tribal remedies. The district judges had a choice of dismissal or stay. He chose to stay. So this tribal court suit was then filed by the petitioners, and their main initial contention is that this court has no jurisdiction to adjudicate the claims they filed, and so they shouldn't have to be here to exhaust tribal remedies in the first place. But that brings me to the main initial point is that we think this court clearly does have subject matter jurisdiction to adjudicate this, subject to all applicable defenses, which is going to include sovereign immunity in some of them. When the petitioners came to the Golden Moon in October 2021, they came into the building with intent to stay there based on a reservation they had obtained for a room. And when they were told they'd have to wear a mask, they didn't want to do that, and ultimately were given a choice of leaving or wearing a mask, and they left.
Objection, Your Honor. We weren't given a choice.
They were given a choice. They were told, you can't stay in here. It's in their pleading this way.
Objection.
You can't stay in here.
Well, just let him finish, and I'll let you raise your point. This isn't a factual.
They were given a choice of either putting on a mask or they would have to leave. And when they refused to put on the mask, they were escorted off the property. That's in their own pleadings. You can't deny that. Now, that reservation is a form of contract between the tribe and them, that hotel reservation. We've cited case law in our briefing that hotel reservations are typically routinely recognized to be a form of contract, page 10 of our main brief. And a contract between the tribe and these petitioners, non-Indians, is a form of consensual relationship with the meaning of the Montana test for tribal court jurisdiction. That consensual relationship gives rise to this court's jurisdiction because their complaint is they were denied the benefits of the reservation. Their plans stay here. In their pleading, they say we were denied the opportunity to enjoy the place and all that, and that establishes the second requirement of tribal jurisdiction, which is the nexus test. Nexus test requires some logical relationship between the claim that is before the court to be adjudicated and the contract which gives rise to tribal court jurisdiction as a consensual relationship. And since their pleading says we were deprived of the benefits of our reservation, our right to stay here and benefit, from the place, that establishes the logical connection between claims before the court and the underlying contractual relationship. They basically say when they were denied entry, unless they wore a mask, that denial violated a number of constitutional, statutory rights that they claim to have. So that we feel that the nexus test is clearly satisfied. They initially specifically referenced their reservation in the first lawsuit. They didn't reference it in the second one. The court, in federal court, recognized that they couldn't take back their admission they had a reservation. In this case, in the complaint, they don't mention the reservation, but in their response to a motion, they admit they had a reservation. So, in terms of the Montana test, let me just read you a section from, well, actually, let me just add. We feel like we've established the core basis for tribal court jurisdiction just on what I've said. And in their response, they've given two reasons why they don't think that the reservation is sufficient to be a consensual relationship that anchors tribal court jurisdiction. One is they're saying that the imposition of this mask mandate somehow invalidated the reservation, because when they got the reservation, it didn't say you got to wear a mask to come in. But it's black letter law that the contracts that are executed in a particular jurisdiction, the law of that jurisdiction is part of the contract. The law of this jurisdiction at the time was that you had to wear a mask to come into tribal facilities. Cited Mississippi case law on that issue in our brief, that any legal requirement that is in existence is part of the contract. You can't avoid that through a contract. So that argument does not vitiate the fact that they had a reservation. It's a consensual relationship. Here's the Mississippi case law. Law enforcement at the time of contract was made forms part of it and is as if written into the contract expressly. And that's the Tucker Printing Company case that we cited.
Objection, Your Honor. May I interject here? Counsel is leading the court to believe that executive orders are always law. However, the CDC, FDA, Biden White House, OSHA,
Let me stop you there. He's making his argument, and I'm going to let you make yours in a minute, so raise those points. Go ahead.
So the mask mandate, again, was authorized by Tribal Council Ordinance 58. It was issued by the chief pursuant to authority conferred by that ordinance, and it was the enforceable rule of law that applied here at the time. Now, they also argue in their response that the fact that there could be federal question or federal jurisdiction over the claims they pled under 28 U.S. Code 1331, 1343, and 1967, I believe it was, the supplemental jurisdiction, 1367, that the fact that there's federal court jurisdiction means that that jurisdiction is exclusive, and only the federal court can hear claims over which they have federal question jurisdiction. the civil rights claims they filed are under, they're basing it on 1343. But that's just wrong. Not only do state courts routinely adjudicate and are required to adjudicate federal question claims if they're presented there, this court has to address federal claims all the time. And the U.S. Supreme Court in the Nestosi case, which we cite in our brief, specifically holds that tribal courts, in normal circumstances, tribal courts, like state courts, can and do decide questions of federal law. So these claims that they're presented, some of which are based on federal statutes, some of which are based on the U.S. Constitution, which I'll address in a minute, or the state Constitution, which I'll address. But a lot of them are based on the tribe's Constitution and the Indian Civil Rights Act. Well, of course, the court's got jurisdiction over those. But the court's got jurisdiction to rule on all of these. It's not novel. This is not an unusual thing. Their premise is that the federal court has jurisdiction. There can be no other court to adjudicate those, and that's just wrong. In fact, the duty to exhaust tribal remedies only comes up when there is federal jurisdiction over the case. You wouldn't be in federal court if there wasn't any federal jurisdiction. So it's always the case that you have to come to tribal court to exhaust remedies if there's a culpable basis for tribal jurisdiction. Federal judges have now said that's true in this case. It's up to this court to determine if the tribe has jurisdiction in the course of this exhaustion process. But we submit that it's very clear that this court does have jurisdiction to adjudicate the claims pled. I'll mention one other angle on this. These are non-Indian parties suing the tribe in the tribal court. Well, Williams v. Lee, the U.S. Supreme Court decision, 358 U.S. 217, 1959, says, if you have a dispute with a tribal party as a non-Indian and it arises from a contract to be performed on the reservation, the proper court to sue in is the tribal court. In that case, the question was whether it was state court or tribal court, but nonetheless, that remains settled law. You sue in tribal court, the tribal court's got jurisdiction to adjudicate that claim if it arises from a contract that was to be performed on the reservation between the non-Indian and the Indian parties. Now, there's also always a question when you have a question of tribal court jurisdiction. It's not only a federal question, is there tribal court jurisdiction under federal law, but is there tribal court jurisdiction under tribal law? These also has to be addressed. We've addressed that in detail at pages 13 to 16 of our opening memo. The Choctaw Tribal Code, the Choctaw Constitution gives the council the authority to regulate retail, wholesale, commercial businesses and to promote and protect the health, peace, morals, education, and general welfare of the tribe and its members. That's Article 1K and M of the tribe's constitution. The council exercised that authority in doing that Ordinance 58, and the chief implemented that policy through the executive order. But the tribal courts have jurisdiction over lawsuits that involve contracts or actions which have significant minimum contracts with the reservation. In this case, it arose, to be performed on the reservation, and the tribal code, as construed by the Williams versus Park Davis case in the Choctaw Supreme Court, and again in the Dollar General case in the Choctaw Supreme Court, clearly affirms jurisdiction when we have a dispute arising from a contract between an Indian and a non-Indian to be performed on the reservation. Same rule applies here. Now, petitioners also claim that the tribe did not have any legal authority to issue the mask mandate. And they're sort of arguing that the tribe's authority that it was exercising was federal power, and claim there's limitations on that. But the tribe was not exercising federal power, it was exercising inherent tribal power. wasn't delegated power. The two constitutional provisions I just read recognize the inherent power of the tribe to regulate and through ordinances to protect the health and safety of the tribe and to regulate commercial operations like a hotel. And the tribe did that, and that alone establishes that as a matter of tribal law, the tribe had jurisdiction under its code for you to hear this case. And then there's a whole separate federal law, Brown, as recognized in Plains Commerce. Tribes have a traditional and undisputed power to exclude persons from tribal land and gives them the power to set conditions on entry to the tribe's land. That's in Plains Commerce at 554 U.S. 316, page 334. That same authority has been recognized in U.S. v. Cooley, recognizing the inherent power of the tribe to exclude non-Indians. So the power to exclude, as the court said in Plains Commerce, includes the power to set conditions on entry. The condition on entry here that the tribe set was, you got to wear a mask to come in this building. And it wasn't just directed at them, it was directed at every adult. Everybody over 2 years old had to wear a mask. And that's the sort of irony of this case. Their complaint is every other word is we were discriminated against. We were discriminated against by being made to wear a mask or told we had to wear a mask. They weren't discriminated against. They were subjected to exactly the same rule that everybody else got. That's not discrimination. That's just enforcement of an across-the-board law that applied to everyone and was equally applied to them. There's also a recognition by the Department of Health and Human Services that tribes like local and state governments have the power to regulate the conditions of entry in their facilities and other businesses in their territory, including imposing mask mandate. We attached a General Counsel Opinion 2004 to our briefing on that issue, just confirming that they recognize tribes, just like states and local governments, have this authority to impose such kind of rules. Unless the court has any questions about jurisdiction, I'm going to move to our grounds for dismissal of the claims. Initially, one of these areas of relief the tribe seeks is money, the plaintiffs, the petitioner seeks money damages. All of their money damages claims have to be dismissed because of the tribe's unwaived sovereign immunity. That is the plain holding of the Peoples case that the court is familiar with, and it's implementing Section 154 of the Choctaw Tribal Code, which gives immunity to its officials and employees and the tribe itself. CRDE is the tribe itself. The Connie Richardson case from the Choctaw Supreme Court reaffirms that recently, and given the unwaived sovereign immunity of the tribe, we have asked that the plaintiff for money damages be dismissed under Rule 12b-1 for lack of jurisdiction of this court to grant them any monetary relief. Now, they did have the one tort claim that I mentioned, which brings into play the Tort Claims Act. The Tort Claims Act, however, does not get them where they want to go. I mentioned before that they had filed a Tort Claims Act notice after they were initially dismissed out of federal court. It was denied because it was not within the 1 year deadline. When they came back after the second federal court case was stayed, they filed another Tort Claims Act notice, and it was again denied because it was not timely. They suggest in their complaint and somewhat in their response that they have a right to tolling of that, but there's nothing in the Tribal Code, Tort Claims Act, that permits tolling when they go to the wrong court. We don't have a general transfer statute here, and the deadline was 1 year from the event, and they did didn't file any tort claims act within that 1 year. But there's another problem with their tort claim. The claims they filed are all about suing the tribal officials and the tribal government for enacting or enforcing tribal law on mask mandate. But even if they had timely filed a Tort Claims Act notice, they wouldn't have a valid tort claim to pursue in this court under the Tort Claims Act, because Section 25151A and E of the Tort Claims Act provides that the tribe's sovereign immunity waiver does not apply to any claim, quote, arising out of a legislative or judicial action or inaction, or administrative action or inaction of the legislative or judicial nature. The administrative action was to enforce the mandate, mask mandate, or arising out of an injury caused by adopting or failing to adopt a statute, ordinance, or regulation. And 25151B of the Tort Claims Act says it does not apply, the waiver does not apply to tort claims, quote, arising out of any act or omission of an employee of the tribe exercising ordinary care in reliance upon or in the execution or performance or in the failure to execute or perform a statute, ordinance, or regulation, whether or not the statute, ordinance, or regulation be valid. The chief's executive order was really the equivalent of administrative regulation implementing the ordinance 50A. They call his executive order an ordinance in their pleadings, but really the ordinance was 50A, and that authorized the chief to issue the executive order, which he did. It's equivalent to an administrative regulation. So there's no Tort Claims Act waiver for sovereign immunity in the Choctaw Tort Claims Act. Now, that only applies to the one tort for infliction of emotional distress, but it does dispose of that, even if they had timely filed the Tort Claims Act notice. And I know that there's a Mississippi case under the analogous state law that basically says you can't toll the statute of limitations on the State Tort Claims Act. There's a 1-year deadline. So we're also allowing that case is in the pleadings, in the motion, the memos. So that addresses the money damage claims. I think it's clear, they're clearly all of them. They also saw punitive damage, which is $500,000, which isn't permitted under the Tort Claims Act anyway. Now, we've also sought dismissal of the array, all their other claims, under 12B6 for failure to state claims upon which relief can be granted. And this is to bar equitable or declaratory relief. It also, the same grounds, the 12B6 grounds that we're going to argue, also bar monetary relief, but you've got to have a valid claim to get monetary relief. 12B1 is jurisdictional, 12B6 is not jurisdictional in the same way, but the same arguments that bar equitable and declaratory relief also bar monetary relief. And I'd like to, I'll just briefly, as briefly as I can, touch each of their legal grounds or legal theories that they think gives them the right to relief here and show that those just don't hold water. So their complaint is riddled with claims based on the U.S. Constitution, mostly Bill of Rights provisions. There's 18 or 20 paragraphs in there that they say their claim is predicated on U.S. constitutional provisions. And the U.S. constitutional provisions and Bill of Rights just don't apply here. They don't apply to the tribe. The U.S. Supreme Court ruled that in 1896 and has never changed its position at times in being made. 163 U.S. 986. This is all covered at page 29 and 30 of our opening brief. Many subsequent cases, including Santa Clara Company versus Martinez, 436 U.S. 49, 1978. There are some provisions in the Constitution that weren't addressed in that case. There weren't any rights, including the Privileges and Immunities Clause. But the Privileges and Immunity Clause has been held in the Fifth Circuit in Daubert versus Gulf Federal Savings Bank, cited on page 30 of our brief. There's no private right of action to enforce any right grounded in the Privilege and Immunity Clause. And their main Privilege and Immunity Clause argument is a right to travel was violated. Their right to travel was violated. But the Fifth Circuit is also held in Harris v. Hahn, cited on page 30 of our brief. The constitutional right to travel is only implicated when a state takes actions to restrict or penalize a person's travel from one state to another. We don't have that here. We have their being denied access to a building on the reservation because they wouldn't wear a mask. Now, in an effort to sort of bolster their position and overcome the clear holdings that the Constitution doesn't apply, they purport to quote the tribe's Constitution in Article 8, Section 1, but they misquote it. They quote it as stating the legislative power of the Mississippi Band of Choctaw Indians invested in the tribal council and should be exercised in accordance with this Constitution and bylaws and the Constitution and laws of the United States are applicable to Indian tribes. Well, that's not what it says. What it says is, here. Yes. The legislative power of the Mississippi Band of Choctaw Indians is vested in the tribal council and shall be exercised in accordance with this Constitution and bylaws and the Constitution and the laws of the United States applicable to Indian tribes. It doesn't say they are applicable. It basically means as applicable, not are applicable as they quoted it. So, again, the tribe's inherent power, as recognized by the U.S. Supreme Court, is not delegated from the U.S. Congress or from the United States. United States v. Wheeler, cited at page 31 of our brief. When exercising their powers of self-government, Indian tribes act as independent sovereigns and not as an arm of the federal government. Indian tribes possess self-governance authority has been regulated by the Congress, but their powers have not been delegated by the Congress to Indian tribes. And then Dinesky versus U.S., the 2022 U.S. Supreme Court decision cited in page 31, reiterating Wheeler's holding that the self-governance powers of Indian tribes are not delegated by the Congress. They are exercised as part of the retained sovereignty of the tribes and not as an arm of the federal government. So, none of their U.S. constitutional claims are viable. They don't state claims upon which relief can be granted because those provisions don't confer any rights on the petitioners, which can be validated against the tribe because the tribe is not subject to those provisions. Now, they do try to state claims under the tribe's constitution and the Indian Civil Rights Act, which is basically identical in text. Their first claim is due process. They never articulate, however, how was their due process violated? What was the protected liberty interest or property interest they were deprived of? They don't say. They claim they had a right to enter the building without wearing a mask, but where did that right come from? Property interest and liberty interest that are protected by the due process clause are defined by local law. The applicable local law in this jurisdiction at the time was you had no right to enter a public facility of the tribe without wearing a mask. So their due process claim just stops right there. They don't have a protected liberty or property interest defined by local law that would trigger the due process law. And this is all covered in page 33 to 35 of my brief case law. The second claim they try to make is equal protection. This argument is clearly fails because they don't allege they were treated differently or more harshly than any other person over 2 years old, which the mask mandate said anybody over 2 years old got to wear a mask. Anybody who sought entry in the Golden Moon facility in October 21 had to wear a mask or they had to leave. They say they were discriminated against based on their race or religion or national origin in enforcement of that, but their pleading identifies only that they were asked to wear a mask, the same rule that everybody else had. So that's not discrimination. They weren't discriminated against. They were held to the same standard as everybody else, and you can't have an equal protection violation unless you're submitted to a regime or an enforcement that is different than the other people that are in the same boat. And you're doing that to them because of their race or national origin or religion. And that just didn't happen here by their own complaint. They make a very brief reference to the Fourth Amendment. And the tribe has the Fourth Amendment, free from unreasonable search and seizure. But they don't claim they were unreasonably searched and seized. They were just told, you have to leave unless you wear a mask. That's not a search and seizure. It's not a Fourth Amendment violation. They claim their right, again, their right to travel was impeded, but that clause does not appear in the Tribal Constitution or the Indian Civil Rights Act. The Privileges and Immunities Clause does not appear in the Indian Civil Rights Act or the Tribal Constitution, so those claims can't arise under tribal law or under the Indian Civil Rights Act. Very near the end of their very long complaint, you can sort of tease out a claim that their right to free exercise of religion was impeded here or was wrongfully and illegally, unconstitutionally burdened. They claim they had a religious objection to wearing a mask. They never articulate, still have never articulated. What is the religious objection?
Objection, Your Honor. It's actually on video. Inside the facility.
You can state that in your response.
Okay.
So, Your Honor, I mean, they said they had a religious objection, but they never identified what the basis for that was. What's the tenet of the religion, and what religion are they talking about? The case law that's addressed this issue, but in particular in the context of the challenges to mask mandates, basically says, if you've got a general, neutral and generally applicable rule requiring a mask, and the petitioner claims that violated his religion, you have got to give some concrete information about how it does that. And as long as the mask mandate is promoting a legitimate governmental purpose, and there's a rational relationship between that purpose and the means chosen by the defendants to promote that purpose, then the only way you could overcome the duty to comply and to use a religion, a free exercise claim to get out of compliance, is if you were in a context where you were forced to wear a mask. You were forced to engage in conduct contrary to your religion. They were not forced to wear a mask. They were given a choice. They weren't herded into a building, made to do something. They were given a choice, comply with the law or leave. And the cases, and we've cited these at page 39 through 41 of our open brief, are uniform in saying that doesn't state an actionable free exercise claim. They don't, basically, it's got to be a burden that is so great that it's actually coercing them to change their, intrude on their religion. Again, they weren't required to wear a mask. They were given a choice. You wear a mask or you leave. If they had been herded in there, forcibly put a mask on them, then maybe they would have an argument. If there was actually a religious basis for their objection, which they've never identified, including on the video, by the way. There's about 8 cases we cite in our brief rejecting this very argument in context of the COVID-19 and the mask mandate. And in regard to the legitimate governmental purpose, if any governmental entity had a legitimate purpose for a mask mandate, it was here. We've noted in our pleadings that Choctaw lost over 100 people through COVID.
Objection 602, he's not an expert witness.
It's in our memorandum, and the court can take judicial notice it was here. The judge was here and knows that read. So we had a legitimate governmental purpose. It was neutrally applied, and they just didn't want to comply with it. And so they weren't coerced into changing their religion or engaging in conduct they didn't want to engage in. They were given a choice and made a choice. That doesn't violate any right, free exercise. They also try to plead a claim under the Mississippi Constitution, but the Mississippi Constitution has no application here to give them any rights against the tribe. They also try to plead a claim under 42 U.S. Code 1983, which is only violated when there are state actors involved. There's no state action here, so that claim fails. Actions by tribal government under tribal law are not state actions that trigger 1983. They next attempt to state claims under 21 U.S. Code 360 BBB-3. Now that is one of the laws passed when COVID hit that gave the Department of Health and Human Service Secretary, FDA, and other people authority to expedite approval of various COVID combating mechanisms, including vaccines and all that. And it basically authorized the Health and Human Services to give recommendations to local, state, and local authorities on using masks as a way of preventing the spread of COVID. It did not require a local authority to do that. It did not require anybody to wear a mask. It just said, we recommend that you enact provisions that require wearing a mask in public places. Nothing in that statute impinged upon or prohibited the exercise of the tribe's inherent authority or state and local inherent authority to require masks to enter public places. And here the tribe wears two hats. They're a business owner and a governmental body. Both hats give them the right to condition entry into their premises on wearing a mask. There is nothing in that statute that supports the notion that that statute prohibited the tribe from exercising its inherent authority to impose a mask. And they then turn to what's called the PrEP Act, which is an amendment to the Food and Drug Administration Act, 42 U.S. Code 247D. And that act, it basically mirrors a lot of what's in the first law, but it did something else, and it actually conferred tort immunity, actually immunity on any claim for liability if you are a local government carrying out a mask mandate in accordance with the recommendations of the Secretary. That's addressed in that advisory opinion 2004 that's attached to our brief. This is actually an independent bar to the money damage liability claims because the tribe's mask mandate was carried out in a way that was in conformity with the recommendations. And the tribe itself is specifically recognized as a body that has the authority to invoke that protection against liability. Tribes and state and local governments are covered in that advisory opinion and statute. So there is nothing in the PREP Act either that says a local government cannot use its own authority to, or business to require a mask as a condition of entry into premises that are under their jurisdiction. So it goes nowhere. There's also no private right of action under that 366 BBB-3 case law cited in our brief on that. So these two statutes just give them nothing, give them no rights that were violated. Then they claim that the tribe's conduct in making it a condition of entry that they wear a mask violated the public accommodation statutes, which is 42 U.S. Code 2008. But all that act does is prohibit discrimination on the basis of race, national origin, religion, etc. In the provision of public accommodations. Again, they weren't discriminated against. They were treated exactly the same as everybody else. So that claim just goes nowhere. They didn't rely on 2001A1, which is a subpart of that same statute. 2001 requires two things to invoke its provisions. You have to prove discrimination, which they can't prove because they don't allege it, and it has to be supported by state action, and the tribe is not a state. So 2001 gets them nowhere on that. There's also 2008-2, here, which they claim was violated. We say they haven't played any valid cause of action under that because you can't enforce, there's no right under 2008-2 unless you can show a violation of a right violated under 2008 or 2008-1. Again, there was no discrimination, so neither A1 or A were violated, therefore there's no remedy under 2008-2. 2008-3 permits a private party to seek prospective injunction relief to stop a defendant from engaging in ongoing conduct in violation of 2008-2. But 2008-2 required proof that there was discrimination. There was no proof of discrimination. There is no discrimination, period. So basically all of those two public accommodation statutory claims fail. They then claim under 42 U.S.C. 1985-3 that there was a conspiracy to violate their federal rights. They don't identify any federal rights. But that conspiracy statute, which really is ancillary to 1983, really applies to state action. But even getting past that, the Fifth Circuit has said that you can't base a claim under 1985-3 on anything except race, religion, and other federal rights protected aren't subject to 1985-3 conspiracy claims. But again, you got in under 1985-3, you've got to have a conspiracy to violate a right. They haven't identified a right that was violated by enforcement of the mask mandate, so they don't have a basis for a 1985-3 conspiracy claim. They also claim common law conspiracy. Again, where is the right that was violated? That supposedly there was conspiracy by the tribal officials to private. They haven't identified an actual right. They also make some kind of claim under 25 U.S. Code 2716, which is a statute that relates to gaming that says if you find evidence of a violation of federal or state or tribal law, you're supposed to report it to BIA or to the National Indian Gaming Commission. But that doesn't give rise to a private right of action, even if there was a duty, even if something happened for which there was a duty to report, it doesn't give them any cause of action. And there wasn't anything to report. Finally, they argue some kind of state law-based claims based on 25 U.S. Code 1322B. Well, that's Public Law 280, which doesn't apply in Mississippi. Mississippi is not a 280 state, so state law has not been made applicable to the reservation, as it has in some other states where Public Law 280 has been used to extend state court jurisdiction or state jurisdiction. And I'm almost to the end. They have a long section in their response, pages 9 through 11, sort of a discourse on individual rights, which is interesting, but it doesn't identify any right to be free of a properly enacted and enforced mandate to wear a mask in a facility owned by the tribe. And it's sort of an abstract discourse. It's almost like reading Rousseau, but we're not living in, a state of nature. We're living in
That would be
a
like
country
it.
of laws. And this jurisdiction has its own laws. We also know that just as we think we've identified, that they're proven that there is no viable cause of action here for any kind of relief, equitable, money damage, or declaratory. We also know that the mask mandate has been rescinded. It's not enforced. So the notion of an injunction to enforce it now seems somewhat moot. And this case law is going both ways on that, depending on the circumstances. But we think here, it just doesn't warrant an injunction to stop something that isn't happening. I believe I will almost wrap up here. We're basically asking the court to dismiss all the money damage claims for failure, there being no waiver of the tribe's sovereign immunity either for the one tort claim or for any of the other claims based on peoples in section 154 of the tribal code. We believe that all of the other claims are failed state claims upon which we can be granted for the reasons I've stated. And that in regard to the money damage claim, the PREP Act actually confers immunity on the tribe for any claim for liability. And we ask the court to enter an order dismissing this entire lawsuit on those grounds.
Thank you, sir. Mr. Brown or Mr. Sibley?
Yes, sir.
I apologize.
Brown.
Okay.
Sibley, yeah. No worries.
I won't be quite as prolix here. We're going to just rebut a couple of the presumptions by Mr. Carl.
Give me 1 second, let me move some paperwork around and get you.
Yes, sir.
Go ahead.
Well, I'm going to start with the doctrine of sovereign immunity. It is up to this court, and we will agree that it is up to this court to interpret whether the initiation of the Indian Civil Rights Act of 1968 is actually a waiver of sovereign immunity for the tribe. With that, we're going to go into the consensual relationship. Carl has spoken greatly to the consensual relationship, but in order for a contract to be in place, we must have an offer, acceptance, and then consideration. I would ask the council at this time to provide proof of any consideration, money exchange between the tribe and the plaintiff.
Well,
It was a reservation.
I'm sorry, kind of the same rules. Y'all are going to address, this is a
Okay.
motion to dismiss the claim.
Excuse me, Dan.
So address it to me and then he can respond and reply.
Yes, sir. So, For consensual relationships, tribal members, there must be something private exchanged for this commercial activity to include a private consensual relationship. And that's out of Plains Commerce Bank and Long and Family also. What I also want to touch on real quickly is Carl's assertion that the PREP Act immunizes local government when it does not. The immunity.
Let me go back through your consensual relationship argument. I kind of
So-
talking, so
Not every consensual relationship with a tribal member is subject to tribal jurisdiction, even if it has a nexus to the non-member conduct at issue. In Hicks, the court wrote that the relationship must be private, which means it has some commercial dealings. And then we go back to the essential elements of contract, which is offer, acceptance, exchange. What we contend is that the offer cannot be contingent on a violation of our equal protection, which is to enter public facilities without discriminatory practices. Wherefore, I know Carl wants to object that 2-year-olds had the right to come in, which therefore eliminates the entire criminality of the ordinance anyway, because if we're going to exempt one group of people, it cannot be criminal in action for the other group of people. That's the very idea of discrimination, is that we're going to grant privileges and immunities to a certain class. We're going to identify a certain class. If you wear this mask for us, if you take this vaccine, we're going to let you in. Well, that's discriminatory, and that's a violation of the rules of conscience, life, liberty, and property, which is the entire basis of our federalist system, right? It's the absolute rights of the individual which are protected and the relative rights of the public. And that's...
So the equal protection, it has to do with the exception for the 2-year-olds?
Yes, and it's in our plea. We exonerated 2-year-olds and people of that class. And then in the ordinance, Chief Cyrus Ben allowed a violation of the chain of custody, people to build their own masks with bandanas, scarves, or any other suitable fabric. That does not specify any criminal activity. Now we're telling people to go home. You can make a medical device at your house, which is in violation of the EUA authority, by the way, by the HHS director, and allow them to go make their own mask with zero chain of custody and call it a medical device. That's crazy. That's absolutely ludicrous to think that a chain of custody is combined in that action, and therefore exonerates people to walk around with some type of mask on. Another issue here is in Lewis and Clark, personal capacity suits. We're asking for declaratory judgment against Chief Cyrus Ben ordinance, which violated the civil rights within the Choctaw Constitution, which did unreasonably search and seize the plaintiffs because our liberty was stopped. At the moment of arrest, liberty has been halted. This principle is as time-honored and simple as any. So at the moment that our liberty was stopped, we were surrounded by people with guns and told we had to wear a mask. Our liberty, our rights, and then our property, which includes the right to conscience, correct? It does, to not apply yourself to laws and mandates of the executive branch that violate the conscience. This James Madison, this William Blackstone, John Locke, I don't care which one of the primary documents you want to go to. This is a principle that's been held in stone since the institution of America.
What's the criteria for that?
Well, that the right of conscience is also a property right. This Lockean theory, the second treatise of government and William Blackstone's, that this natural right is reserved to us, the people, not to local governments and executive branches of government who will willfully and negligently violate these rights of property. So property isn't just, we understand this, property isn't just your physical papers and things. It's your religious beliefs is your intellectual property. Your moral conscience, what's right and wrong is your property also, right? These are,
By what method is that determined what one's conscience is in regard to law or rule?
so, well, then we go by the nature of law. We're in a federalist society. So the first thing protected is the people to be safe from unreasonable searches and seizures, right? Again, at that point, you have your due process protection, and that goes from the federal all the way down to local government.
Well, you went to search and seizure instead of the.
Well, yeah, so when a local government or the federal government institutes a policy, an executive order, and operates out of the executive order, it's the right of the people to challenge that executive order as being non-constitutional, as which we have done. Many pro se's have done this. The FDA's laws, the CDC laws, the HHS laws, Biden's laws. These are all losses all the way across the board for the COVID nonsense. And it has to be losses, or we just give up our federalist system. But what we're saying, we contend is that not only do we have a religious right not to join the Branch Covidians in their nonsense, but we also have a moral duty to say no. To impose this by the government to restrict life, liberty, or property. And that's our contention on that particular issue. Furthermore, we would continue to state that the relationship must be private. Us calling, get a reservation, and never actually going all the way through, never getting through the door, and then being escorted out by people with guns is a restriction of our life and liberty. And that involves the Equal Protection Clause and traveling between states. Executive Order 13132, which has to do with tribes and Americans, states unequivocally, the people of the states are free, subject only to the restrictions in the Constitution itself or in constitutionality authorized acts of Congress to define the moral, political, and legal character of their lives, acts of the national government, and we know this, that the Biden administration and Xavier Becerra met with the tribal Indians in January 26, 2021 to initiate the federal response to COVID. This was a federally funded, moved action to require people to conform to the policies of the Biden White House, HHS, and FDA and CDC. Acts of the national government, whether legislative, executive, or judicial in nature, that exceed the enumerated powers of that government under the Constitution violate the principle of federalism established by the framers. So therefore, anything and everything that was initiated under emergency use authorization, which included masks, included vaccines, were under statutory authority of the federal government. Those federal agencies directed local and state agencies to abide by their guidelines. Of course, in the little print, this is recommendations and guidelines, but what did they do? They held the carrot and the stick the whole time. We'll either pay you monies or we'll come after you, and that's what the federal government did for 3 years. So I'll move on into the next and final phase, because I don't have to take up much time. I really don't. The tribal government, the chief, and everyone else in federal, state, and local government had a standard of care. They had a duty of care to their citizens to not violate their life, liberty, or property. Okay? And when they willingly, knowingly violated those principles, they were negligent per se. Okay? Negligence gives a personal rise of a cause of action. Now, the other issues, whether this court is actual judicial in nature or quasi-judicial, I can't answer that. I've tried to find that answer myself. I'm not sure. But what the truth is that the Indians aren't sovereign. They're quasi-sovereign. Okay? There is a degree of separation there where we use words that mean something, But when you directly violate the life, liberty, and property of another, you are responsible. You have a duty of care to everyone around you. And any time that the inalienable rights of another is violated under executive order or legislative action, it is the right of the people to challenge those actions. And that's all I really have to say about it. I really don't have to go much further. It's in our complaint. We fully intend to see this all the way to the Supreme Court if we have to. And it's on moral principle. It's on nothing else.
And I would just say that 1331 U.S. Code gives exclusive jurisdiction to constitutional right violations, which is our life, liberty, and property, which is what occurred walking in the Golden Moon.
And I just want to say this too, because we were 2 years into it, man, Judge. I had traveled all the way up to Washington, D.C. at this time, and I had passed 8 states on the way to this place. Not one place restricted my access. And I didn't wear a mask the entire time of COVID. I will not take a vaccine because it's a moral principle for me. However, at that time, I had gone all the way to Washington, D.C., come all the way back down for political reasons, and come all the way back down, and it was restricted right here. That is not equal protection.
Mr. Brown, did you have anything since you both pro se? I'll let you both.
I appreciate it.
Appreciate it.
I think we covered it.
I think we've covered what we needed to. Yeah, we're good. Thank you, Your Honor.
All right, thank you. And as the movement, Mr. Brown, you have an opportunity to
I have a
require.
couple of things I'd like to say, Your Honor.
Going back to the notion that liberty is violated when you have an arrest, that's true. We didn't have an arrest here. We didn't have a detention here. Their complaint says, John Doe, this is paragraph 36, John Doe 1 told plaintiffs that the only way they would be allowed to continue on their way in this facility would be to put on a mask. Dialogue back and forth, arguing back and forth, and ultimately they chose not to put on a mask and they chose to leave. They were not seized, they were not arrested. The Indian Civil Rights Act does not waive sovereign immunity pursuits in tribal court. The Choctaw Supreme Court has so ruled in the people's case in regard to money damage claims. The reservation, again, I told you the tribe had 2 hats. When they were dealing with the petitioners in regard to their reservation, they were a commercial operation owned by the tribe, operated by the tribe, and the
Objection, we spoke to no member of the tribe for that reservation.
They got a comp from a tribal employee who was not.
He was no longer an employee. Let's be accurate if we're going to talk
He
facts.
got them a comp reservation, that's what they pled. And that's a private commercial reservation, it's a contract. It doesn't matter how they got it, they accepted it. There's no requirement for more consideration than just the offer and the acceptance. The paperwork alone is evidence of the contract. They've never disputed they have a reservation, and it is a contract.
Do you have the paperwork to present? I'm sorry. I'm just asking if you have the paperwork that you just assumed was there. Do you have the paperwork that was?
I know there was, I've seen the paperwork, I didn't put it in here, but it doesn't matter. They don't dispute there was a reservation, they admit it in their original complaint, and they admit it in their response to this motion. There are no individual capacity suits, plaintiffs here, as in Lewis v. Clark. They sought injunctive relief, which is really running against the tribe itself. And they sought money damages from the tribe and all these people. The tribe's immunity clearly is 154. Let's see here. Again, these arguments about what the U.S. Constitution does and doesn't permit. The U.S. Constitution does not constrain the governmental operations of the tribe. That's why Congress passed the Indian Civil Rights Act. And the tribe has its own constitution that does constrain the acts of government here, but none of those provisions are violated. I didn't even address this, but they did allude to the fact that they have claimed at various times that these tribal courts, like this court, are just administrative bodies, they're not really courts. Well, it's really a court. You have the power to make legal rulings, and the Choctaw Supreme Court has the power to review them, and the Choctaw Council has the power to pass laws that are enforceable in this court.
If you're gonna quote us accurately.
Word here. And I'll just close with, 1331 does not confer exclusive jurisdiction over the federal courts to hear federal constitutional claims. Even if it did, the federal constitutional claims don't apply against the tribe. But the fact is, in National Farmers Union versus Crow Tribe of Indians, the court expressly held that the fact that there was federal jurisdiction under 1331 did not preclude tribal court jurisdiction. That's why they required exhaustion of tribal remedies. Close with that,
I would just, you mind if I say one more thing, Judge?
I'll allow it.
I'm just going to ask for a viva voce motion from you, Rule 52A, where I can get a findings of fact and conclusions of law, please. If, whatever your ruling is, I would just like, yes, sir, I would just like a clear findings of fact and conclusions of law.
Well, I'll issue a written opinion,
Yes, sir.
and how that comes out, of course, will be up to me. This is not a fact-finding hearing. I'll have to make.
That's what I wanted to-
Based on facts that are not in dispute and where we are in this court.
Yes, sir.
On a legal basis.
Okay.
So that's what the
That-
will reflect.
I just wanted to make sure that, I mean, there's not a whole lot of information out there for tribal courts and their actual operation. Very few case laws that you can pull up, and you can't pull up any out of this court. So I just wanted to make sure that that's what we were going to receive.
Yeah, you're
Okay.
written memorandum of opinion and a word.
Thank you. Okay.
We set up that. You're welcome. So thank you all for your work, for your arguments. If you would, I don't know that I've received these by email. If you email your